4CRB now presents Legal Matters, proudly brought to you by Bell and Senior Lawyers. Call them today for all your legal needs on 07 5532 8777. This program provides general legal information only. It's not personal legal advice. Everyone's situation is different, so please seek independent advice for your own circumstances.
That time of the week, it is a very good morning to Andrew Bell from Bell and Senior Lawyers.
It is indeed. Great morning. Thank you for having me back.
Nice to see the sunshine out there, although I hear that you've been suffering under a small flu.
Yes, small children, small flu, and so if I cough or start muting, you'll know why.
Oh dear, there's a lot going around. I'm hearing of RSV and a few other things, so at least you're on the tail end of it. Well, this is the Talkback program. It is your show. It is your opportunity to get a little bit of free legal advice, or maybe even find out whether it is worthwhile having a chat to a solicitor right here now this morning. All you need to do is give us a call on 0755 208888 is the number. Do not leave it to the end of the program. We'd love to hear from you this morning. Now, we're going to be talking technology law. That doesn't mean that your questions need to be limited to technology law. They can be any sort of legal question, whether it is wills and estates or it is to do with someone with a tree over the fence. We'd just love to hear from you this morning. Andrew, well, this is always a fun one because I have a technology background and your previous life is technology, so looking forward to this one.
Yeah, it should be great. To give a sense to those, I can't say I'm specialised in it because there's rules about using the term specialisation, but I've spent a large part of my career designing large, complex computer systems before I became a solicitor, and I'm developing some software right now. So I've sat on both sides of the fence. I understand how the systems work and what can go wrong with them, not just legally. So I sit on the Queensland Law Society's Privacy, Data, Technology and Intellectual Property Law Committee, and I'm on the Australian Computer Society's Committee for Artificial Intelligence, and I'm doing a PhD in cybersecurity law. So if we could say there's one area of law that's my area of law, and that's technology law.
That's fantastic. Well, look, maybe we should start with a brief history, and should we go all the way back to the birth of the internet?
We should. So we've previously talked about Facebook and getting sued for writing on what you put on Facebook and defamation. So I've gone through a little bit back around what happened, where does the law come from relating to these things? So when we talk about technology law, it's a whole suite of things from what happens if you get hacked, how can you responsibly use AI, but also what can you actually put on computers, and what protections do you have? So one of the great advantages that we have about computers is that they can automate and help lots of people very quickly.
Yes.
At the same time, when something goes wrong, it can go wrong for a lot of people very quickly. So it's a very emerging area of the law, and it's not particularly settled. But I believe we have a caller.
Well, there you go. We've got our very first caller. Thank you for taking up the challenge. And it is a very good morning to Tracy. Tracy, ask your question of Andrew.
Hello.
Morning, Tracy.
Good morning.
How can we help you?
Okay. This is a done deal already. It's completed, but I purchased a car on the auctions. Okay? And the model that it was quoted as isn't what they sold me. Okay?
Yeah. So did you not get what was actually on the auction floor, or how did you do this auction? Was it online or was it in person?
No, it was online, and I saw the model and I Googled it and decided that's what I wanted. It was the top of the range. Anyway, it had a sunroof if it was the top of the range and a few other things, but when I got in the car, I won the auction, picked the car up, I paid for it and I picked it up. And then I went to look for my sunroof, and there was no sunroof. So when I got home, I looked at the receipt, which said that it was the top of the range, and the roadworthy said it was one down. Okay, so it had some of the features, of the top of the range, but not all of them.
So what was in the photos? Was the sunroof in the photos, Tracy?
They didn't have any photos of the sunroof. Okay, that's why I didn't pick up on it, because it just had photos of and around the car, and because I didn't go and to the auction and check it out first, it didn't tweak.
So unfortunately, I think you'll probably find that if you buy stuff at auction, it's as is, where is, and they take no liability for the descriptions, provided they've given you the opportunity to inspect it beforehand. So if it was through Pickles or one of those large groups, they typically have a number of days beforehand where you can go in and actually have a look at the vehicle. If there was roadworthy issue, whether you did or didn't take them up on it, I think you'll probably find if they did give you the opportunity to turn up and have a look before the auction, that your liability would be limited, that for no real comebacks. Now, I'd strongly suggest you look in their terms and conditions, but normally auctions, you take it exactly as it is. If they haven't discovered a fault, they say it's up to you to discover the fault, so the term, as is, where is, comes into play. So unfortunately, I think you're probably stuck with not the model that you purchased, but I would check those terms and conditions. Also, have you asked them to see if they will take it back and re-auction it?
Oh, yes, they would, but they wouldn't pay any expenses to get it back there, and I said I would I'd take the money back.
Well, I think that's you've got to decide whether that's worth it to you or not, but I think that's fairly generous of them, because I don't think they have to.
Okay, that's all I wanted to know. I accepted what they offered me, and I'm very happy with the car, but I just wondered what, for the future, if I'm buying on the auctions again, I just assumed if they advertised it incorrectly, there would be more comeback.
No,
anyway,
unfortunately, auctions is a special deal where they clear them out, and they've got protections. Yep. Similar things potentially go for house auctions as well. They give you some disclosure beforehand, and then you take it as is once you've bid on it and the bid's been accepted.
That's fine. I'm happy with the car anyway.
Oh, well, good luck. Right. Thank you, Tracy.
Good on you, Tracy.
Thank you, advice. Okay.
You're welcome. Bye-bye. All right. Well, if you'd like your question answered just like Tracy did, any legal topic is on the table this morning. 0755 208888 is the number. Do not leave it to the end of the program. Now, we are talking technology law this morning, and we just started to explore the topic. So how about we how the internet was created, and maybe a legal crisis of CompuServe AOL. So we're going to go back and set the scene, I suppose, to where it all began. Absolutely. So the internet, I think everyone will agree, has changed lots of things, but it's always been fluid and changing, and it's changing right now. And when things first came out, you had to dial up to individual computers. Colin and I were talking about it before the show, banks of dial-up modems, etc. And as part of that, individual companies effectively launched their own internet. They were small, some of them were curated, some of them weren't. So in the United States, CompuServe, Prodigy and AOL were the big companies. AOL was mailing floppy disks and later CDs to everyone who would take one. And you'd dial into their network, and that would be your gateway to the internet. Now, what happens when those users start putting stuff up there that's potentially libelous? So people start commenting on so-and-so did this, did you see that, I don't agree with. And the people who are writing about it, obviously, the subjects of that don't necessarily like being criticised. So around 1991, so very early really in the internet days, there were a number of cases. So one case, Cubby against CompuServe, there was a New York federal case. CompuServe hosted a forum where third parties could post, and one of those included some defamatory content about a journalist. The court found that CompuServe was like a library,
And traditionally, libraries, if something's published in a book in the library, aren't held liable for what's in that book. So they were seen as a passive distributor that had no editorial control over what the users posted, and they were found not to be liable for the actions of their users.
And this starts the foundation of what we have today. But we'll continue that discussion in just a moment. We have Joanne on the line. Joanne, ask your question of Andrew.
Hello, good morning.
Good morning.
You're probably not going to tell me off for doing this, but...
That's not a nice way of starting the conversation,
If
Joanne.
everyone did everything perfectly, I wouldn't have a job,
impressed,
Joanne.
But anyway, we'll see how we go. My mother and father, many years ago, my sister arranged for their wills.
Mm-hmm.
And my father passed away and we didn't have any problem at all with his will. They were in Adelaide, and my mother has since moved up here. So I grabbed the same will and just retyped it out and got her GP to sign it as a reference, to sign it as a witness, and the nurse. And I thought, yep, that's all done. And then I've since found out that, so the doctor signed it in black pen and she signed it in blue pen. Is that a problem?
So it's potentially a problem. So in Queensland, anyone can draft a will, and you just need two people who aren't expected to inherit, who are adults, to sign it, who are in the same room as the person when it was signed. So typically you use the same pen, so there's no question whether they were in the same room or not. If there is a question when you apply for probate, then you may need to get a letter from the GP or the nurse to say they were in the same room, and you can put that in as an affidavit. Because, it's technically fine to use different pens. But if someone disputes the will and raises the question about whether there were three adults in the same room at once and there's different pens, it looks a bit suspicious.
Okay, so should I get the GP to do that now? Or you wait till...
Well, is your mum still around?
Yes, she is.
Can you reprint it and get two other witnesses to sign it?
No, she's got dementia.
Okay, well, if you could get the doctor to write a letter that you would include in the future, just to confirm the circumstances of when they signed it and who they signed it with, I think that would cover you legally in the future.
Excellent. Oh, that's very helpful.
Because the dementia thing, for those who aren't aware, but you may be, is that, if you don't have the capacity to make a will, in that you understand the implications of what you're signing when you sign it, then that will can be challenged as being invalid. So making a new will, once she's been diagnosed with dementia, is going to be very difficult. So, I would say, if the witness is able to make a statement that supports it, and you could put that in as supporting material when you file... when you eventually have to file the will, I think that's as good as evidence as you're going to get.
All right. Well, that's terrific. Thank you for your help.
No worries. Thank you, Joanne.
Thank you, Joanne. Well, there's something that I didn't know, and we're diving in. Maybe minutiae is not the word to use, but the finer details of what's kosher and what is not.
It is, but sometimes those things that aren't kosher or aren't quite right can cost you a lot of time, stress and worry, so...
just the fact of someone chose to use the pen in their pocket at the time as opposed to the same pen could be of issue.
Yes. Well, even if there's staples holding a will together and someone's removed the staples before submitting the will, there'll be questions made as to whether pages were substituted and why the original attachments on the original document aren't there. People are very worried because there's lots of money at stake and the wishes of someone who's no longer around. They take it very seriously to make sure that what is intended to have been given away is actually what gets affected.
Wow. Well, there you go. All right. It is your program. This is your opportunity to get a little bit of free legal advice live here on the radio. 0755 208888 is the number to call. And we'll get back to our topic of the day, which is technology law. And we've just set the scene, haven't we? We've gone all the way back to the birth of the internet. And,
we said early internet. It was first deemed in America that in 1991 that an internet service provider is like a library. In 1995, the complete opposite was found. So a different company called Prodigy this time had marketed themselves as a Christian family-friendly platform. So they had community guidelines, they had filters to moderate posts, they blocked parts of the internet in case they didn't agree with its content. Again, someone posted something that someone didn't like and it was available through Prodigy. The court found that because Prodigy exercised editorial control and because it tried to moderate, it wasn't like a library anymore. It was publisher. And because publishers like newspapers are liable for what they'll publish, Prodigy was held to be more like a newspaper than a library, and they were responsible for an anonymous user's defamatory posts. So now we've got two different areas of law in America. One says, go for it, post stuff on the internet. The other one says, everything, if you try and control it and do the right thing, you're going to find yourself in trouble. So the industry didn't like that. They found it very difficult to operate on that basis. And knowing American politics and American law, there would have been lots of lobby groups behind the scenes.
Oh dear, the effects of young children.
Yes. But eventually they decided this needed to be solved by law, and they published a law, the Communications Decency Act, that said no online platform will be treated as the publisher of third-party content. So they sided with the library example. But even for people who are publishing things, so this is well beyond where we previously were. So this is what gave rise to Facebook, Twitter, YouTube, none of which existed yet, but I would argue that they couldn't have existed unless this particular law came in.
And that's the Digital Millennium Copyright Act. Is that what we're talking about here?
Yeah, 2 years later, there was even more reforms. The DMCA, the Digital Millennium Copyright Act of 1998, went down and put in a vast suite of laws relating to the internet. And of most important to Australia and most users is Section 512, which also talks about copyright, where it says if a user uploads infringing content, the platform hosting it won't be liable provided they comply with the notice of a takedown. So you may see DMCA linked on various Facebook, etc. posts where someone can report it if they believe that's their content. Now, if they don't act, then they can be held liable. But essentially, we now have the ability to be able to set up a company that doesn't moderate things, that only takes down stuff if they have to, and that's how you get these wide-ranging social medias with every possible opinion on them, and people aren't getting sued. Yet you hear me talking about how if you post stuff that's not an opinion or not protected content, then you are liable to be sued. So.
And it's funny how just the simplest of good intentions here, without understanding the background and the foundations, can get you into trouble. We have a website here at 4CRB. We invite other charitable not-for-profits to post their information on the website so that you can promote community events, let's say, and someone posts a copyrighted photograph. Who's in trouble? 4CRB is.
Well, 4CRB, if you comply with the DMCA takedown, could be seen as a publisher.
There's, yes. Well, anyway, we were at the time and we had to make some apologies and sorted ourselves out there. This is your program. It is got about 7 minutes left in it. We'd love to hear from you. 0755 208888 is the number to call if you have any legally orientated question this morning for Andrew. He'd love to take your call and answer that live on air. While we're waiting for a call, we might take this juncture to go to a message from our sponsor.
The greatest gift you can give your family is certainty. Our trusted sponsors, Bell and Senior Lawyers, can help you put the right plans in place, from wills and estate planning to family and property law. Take the first step today. Call 07 55 32 8777 or visit bellsenior.com.au. Bell and Senior, trusted guidance when it matters most.
That is correct. Well, we are in legal matters this morning, and this is your opportunity to get some free legal advice live on air. 0755208888 is the number. Could be just something simple like a neighbourhood dispute, putting up a fence, wills and estates, but whatever it may be, we'd love to hear from you. 7 minutes left in the program. Do not leave it too much longer. We're talking technology law, and we were just going through the foundation of the Digital Millennium Copyright Act. We talked about what it stands for in America, and I'll pose the question. Australia has followed suit, or we have to follow the example of America.
So you may remember that there was a free trade agreement signed in 2004 between Australia and the United States. John Howard, I think, instigated this, and one of the requirements from that law was that we incorporate parts of the American Digital Millennium Copyright Act into Australia. So we did, but we didn't put them in completely, which is an interesting catch. So Australia has these safe harbour provisions similar to what's available in America, but it says it only covers what's called a carriage service provider. So this covers telcos, it covers ISPs or internet service providers, the people that you connect to the internet with, but it doesn't explicitly cover those big platforms, Facebook, YouTube, Google, etc. So there's some interesting law that has come up in this space, but it's still not completely finalised.
That's very interesting. We'll move to another caller. It's a very good morning to John. John, ask your question of Andrew.
Quick one, Andrew.
Good morning.
Yeah, good morning, Andrew. Quick one. Dementia, Andrew. Who says you've got dementia? You've got dementia, Andrew. Who said if somebody says you've got dementia, Andrew? Mm-hmm. Who's got the black and white to say it's not old age memory?
Okay, so it all depends on the context. If we're talking a medical diagnosis, then typically it'd be a geriatrician or a panel of people who deal with older medicine. If it's legally, the lawyer signing a document has to be very careful, and they won't say that you've got dementia. However, they need to ask enough questions to be satisfied that you meet that capacity test. And capacity that we were talking about before is the ability to understand the ramifications of the decisions you're making at the time. There's definitely case law. I was involved in a big case with that went to the Supreme Court that talks about how capacity comes and goes. And while someone may today understand what's going on, next week they may not understand what's going on. For the purposes, though, for capacity, if you have an enduring power of attorney, if you've given out your authority saying on the ability that I've lose capacity, that these people can take care of my affairs, typically that will be a medical professional who will write a letter to say, in my professional opinion, this person no longer has capacity, and that's generally taken to be accepted by the courts.
Is that solicitor, doctor, or specialist?
So normally my advice to my clients, if they're concerned often about their parents and they want to enact the EPOA, is to go to a geriatrician who specialises in making these diagnoses, get them to do the full suite of tests, because there's some shorter tests, an MCOA and MCSE test, that start to talk about cognitive decline, but then there's more definitive tests to see whether you've lost capacity. So if you really want a final determination, go see a medical specialist, but there may be other tests that are required in the interim.
So the old age memory is dementia, yes or no? The word old age.
The doctor.
Okay, so I'm not a doctor and I don't define it. I can help discuss capacity. But again, if you want a dementia diagnosis, go to a medical professional that specialises in those.
They said to my wife, "You're not here, dear, to take your licence off you." And 10 minutes later, I went to the doctor, and the doctor says, "Oh, you've just lost you no longer can drive. You no longer can drive." Straight to her, and knocked her on the head. Yeah, it's like cutting your legs off, Andrew, when you lose your licence.
Well, that'd be awful, but
it is.
if you want a second opinion, get a second opinion would be my advice.
Oh, yeah, everything comes that quick, Andrew. Your brain doesn't come in quick enough, does it? Yeah,
Look, dementia is a slippery slope, John, having seen a number of it around the station as well as other people in my family. It is a medical diagnosis. I know that you can sit there and argue that it's something different, but the doctors do know what they're talking about.
Well, we only hope, don't we?
We do.
Yeah.
Thank you, John. Thank you for your question. We're moving on to Debbie. Debbie, ask your question of Andrew.
Hey Andrew, how are you?
I'm great. How are you, Debbie?
Not bad, thanks. I won't take up too much time. A very dear friend of mine passed away a few months ago without a will.
Mm-hmm.
She had a niece looking after her who, she was very sick and nearly bedridden. Her niece got her to sign a blank will, and she said she had a policeman friend down in New South Wales that would sign that. And she said, "You tell me what you want to do and I'll write it in the will." The lady has since passed away. Her other niece overseas has contacted me asking if I know what she wanted to put in the will because they don't think this will is legal. Should they go get a lawyer and discuss it? Because the niece here will put in the will that it's all to go, the estate's to go to her.
Okay, so has this been applied for to go to probate?
No, not yet, no.
Yeah, well, I would advise that both parties would get some representation and discuss what's going on before it's submitted. Yeah. Otherwise, after it's submitted, there are strict timeframes to dispute the will, approximately 6 months. So, and if it's not a valid will and there is no previous will, then the rules of intestacy would apply, which typically, if she has 2 surviving relatives, would be divided equally amongst them.
That's what she has. There's 3 witnesses that she's spoken to before, and that's what she wanted to put in the will, that the two surviving relatives, divide the estate. But the one that's here has made it out to herself completely and left the other one out.
And do we know if she was a witness on that will?
Well, she's got her own family as witnesses. She said she had a policeman friend down there that could witness this lady's signature, because one's in Queensland, one's in New South Wales. So she just got her to sign it and took the will home, and was going to fill out what she.
Well, you can't fill in a will after it's been signed, and there's strict rules about modifying wills, and you need 2 adults who aren't going to inherit there to witness it. And typically you would also try and isolate the person who's signing it from anyone who is going to inherit before it's signed, to make sure that they can ask questions to satisfy themselves that there is no impropriety going on. But this does sound, on the face of it, like this could be something that could be challenged either for being unfair or for undue influence, or potentially if it was filled in later, that could also be tampering with a will, which I believe could be a criminal offence depending on where you do that.
Yes, yeah. Well, we have there's 3 witnesses knowing that that's what she did, so it's best they get legal representation.
Yeah, I would strongly recommend that.
Excellent. I really appreciate your information. Thanks, Andrew.
Thank you for your call, Debbie. You too.
Thank you, Debbie. Well, there you go. We're at the end of the program. In fact, we're slightly over and pushing into local news. Thank you very much for your time this morning, Andrew. It's been a great program. We really didn't get to explore that topic the way we thought we would. The callers took over, didn't
but I really enjoy people calling in. I think that's what makes the program. So we will continue with some technology law next week.
Thank you for your calls this morning to all those who called in. Andrew will join us again next Tuesday morning at 9 a.m. If you'd like to explore a copy of this program or review the information we provided, a copy of the program will be on the 4CRB.com website as well as the bellsenior.com.au website. Thank you, Andrew.
Thank you, Colin.
You've been listening to Legal Matters, proudly brought to you by our trusted sponsor, Bell and Senior Lawyers. Call them today for all your legal needs on 07 55 32 8777. A copy of this and past programs and all relevant resources will be available for you to replay or download on bellsenior.com.au and 4crb.com.